Hey, what's up guys? It's Clint Coons here, and in this video, we're gonna talk about wholesaling and how you can use a novation agreement versus an assignment of contract. Okay, let's get started. Okay, so here's the deal. When it comes to wholesaling, what are we doing? If you're a real estate investor here, you're basically entering into a purchase and sale agreement with a seller to buy a piece of property. So you're essentially tying that property up under contract. Now, a wholesaler then wants to take that contract to purchase this house and find an investor and sell them the contract for a fee. So then the investor now over here can work with the seller to buy the property. Now the mechanics of how this works is it really comes down to what type of agreements are we putting in place between ourselves, if we're a wholesaler, and the seller, and then the agreement between myself and the investor who ultimately wants to buy the property. Now, I've done this both ways. So my real estate portfolio that my partner and I own together, we started working with wholesalers when we went into certain markets, and that's how we built up our initial portfolios, was through wholesalers. And so essentially it would work like this. The wholesaler found the deal, they would come to us and say, hey, do you want to buy this property? You can step into our shoes, pay us some money, and then it's your deal from there. Now, what's important is how you structure this. So a lot of wholesalers, what they'll use is an assignment. Okay. Now, an assignment means this, that when you entered into the agreement with the seller, you made sure in your purchase and sale agreement that you could assign the contract to another party, meaning I can step out of this agreement and I can give it to the investor, and now the seller is bound to sell the property to the investor, or if the investor wants to enforce that agreement. So the way we typically do that is we would write in our contract, if I was buying the property under my corporation, ABC Inc. and or designated entity would be the way we would write the offer. Now, you're not always going to do that. It depends on the market. I mean, one of the things that I've experienced before is that when I come into a situation with a seller and I throw on there the name of my limited liability company, for instance, and I put and or designated entity on there, they can get the impression that I am maybe someone who's just looking to flip the property. And so some sellers will shy away from that when they see the offer come in that particular way. So maybe what you do then is you put together your purchase and sale agreement that you write up that allows for the assignment of that contract. And so you put a clause in there that this agreement may be assigned over to a third party. So that's another way to do it. So you don't have to specify in the offer that's for certain language, ABC Inc. and or designated entity, which gives you the ability to transfer it, or what a lot of people have used in the past, and or assign. So you just got to get a feel for it, what works based upon the seller that you're approaching. And the reason I bring this up is that I actually lost a deal because the seller assumed that I was coming in to maybe wholesale the deal or mark it up or do something and make more money on it, that there was too much meat on the bone, and so they refused to do business with me. And the reality was I was planning to keep the property, but I realized I'd made a mistake there. So it changed my thinking on how I approach this. So anyways, so let's assume that you put the assignment language in there and you want to use that. So what you'll do then is you'll assign the contract over here to the investor. So now the investor can step in and acquire this property. The problem with the assignment is that when I assign the contract to this person, remember, I'm the one originally that entered into the agreement with the seller. It does not relieve me from any claims the seller could have against me if this deal goes south. What are you talking about, Clint? Well, let's assume that I transfer this contract to this investor here for $5,000. And I put down $2,000 earnest money on this deal. And now the property's tied up between these two. This guy's supposed to close on this property here. This investor decides, I don't want to do the deal, and he walks. Now, the seller on this deal right here, not happy. He thought he had his property sold. And in point of fact, maybe this property now that when we tied it up under contract, we tied it up for $100K. Turns out that the market dropped during the process while this property is held, and now it's only worth $85,000 in that particular area. So the seller could turn around and sue me over here for damages. That literally. So many investors think that your damages are capped at your earnest money, and that's not the case. You can actually be sued for the decrease in value that occurs if you fail to close on the property. So that could be an issue right here. So whatever contract claims that are in there that the seller may have recourse against you for failing to close, I know you're thinking, wait a minute, Clint, I'm not the one closing. It was this investor over here that was supposed to close. Yeah, but he didn't. See, with an assignment, you're still liable under the contract. You just have to give the ability for someone else to purchase it on your behalf, but the seller doesn't have to say, well, my claims only run to this assignee. No, they can still go back to you because you're on the agreement. So this is why a novation agreement may be preferable. In fact, maybe it should be preferable. It should be the one that you use when you're wholesaling real estate. So the difference between these two is that when you put together a novation agreement, you're going to basically do the same thing here, where you're going to enter into a purchase and sale agreement with a seller to buy a piece of property. But the difference is that in this purchase and sale agreement, you're going to have a clause in there that states the seller agrees that you can novate this agreement to a third party, and they agree that they will accept that and they will basically sign off on it and enter into an agreement under the same terms with this third party, and they can't object. So you put that clause in there. And so what that means is that when you find your investor and you're ready to assign your agreement, because you will assign it, you're going to sign that contract over to this investor. What will occur is that you'll tell the seller, hey, I found an investor to step into my shoes. I'm assigning this agreement over. It's going to be novated over to them. Seller, you're obligated per the purchase and sale agreement now to enter into a new purchase and sale agreement with this investor here under the same terms as this. So the seller, they're not injured here because they're stuck by now agreeing to sell to this party. But here's what you've done. You've taken yourself out of this agreement. In fact, the way you do this is called a novation agreement between you and, so it's basically a three-way agreement here, which it states that the seller releases you, agrees to only do business basically with the investor, so you no longer have liability under this initial purchase and sale agreement because it's now canceled and it's been substituted by the new agreement. So if you're wholesaling property, or if you're just flipping property, you want to leave yourself open so that you could possibly kick it off to an investor, and that if you decide you didn't want to close on it, you may want to consider using this novation language in your purchase and sale agreement, putting a novation clause into the purchase and sale agreement, and then creating a separate novation purchase and sale agreement that these two are going to enter into that relieves you of a liability under that contract. Okay, now, here's the thing. Before you hit me up and you say, well, Clint, where the hell do I get that language? Don't worry about it. If you look in the show notes, I've actually included for you some sample language that you can use in your purchase and sale agreement, and you can use over here for this subsequent purchase and sale agreement, replace it purchase and sale agreement that relieves you of any liability there. Now you can get even more creative with this. I have one client that actually puts in here on his purchase and sale agreement that the seller gives him a power of attorney just to close on this on his behalf. So when my client finds this individual right here, he can enter into this secondary purchase and sale agreement on behalf of the seller as his power of attorney. Now that works for him. I'm not going to give you language to do that because I think this should be sufficient for you right here, because the language that I've included ensures that the seller is obligated and bound to enter into this new agreement within a certain period of time. And you can fill that in 3, 5 days, whatever you want there. So anyways, check out the language below. That's the difference between assignment and novation. If you're wholesaling property, if you're making offers and you think you want to leave that open, definitely consider this as an option for your next real estate deal. Hey guys, if you liked the video, hit the like button and be sure to subscribe to the channel. Thank you and take care.